Good morning, ladies and gentlemen. Today is Thursday, November 19th, and we are in the continuation of the hearing in docket number 2019-182E. I apologize for us coming online a little bit late. We've had a slow computer trying to boot it up this morning, but I think we've got it going now and are ready to proceed. First order of business is let's do a roll call of the commissioners. District 1.
Present in the hearing room.
District 3.
Present in the hearing room.
District 4.
Present virtually.
District 5.
Present virtually.
District 7.
Present in the room.
I'm present for District 2, and our District 6 chairman is on military leave today. Let's take appearances. I know that counsel for the commission has done a roll call with witnesses and attorneys, but for the record, I'll go through the attorneys. I won't go through the witnesses. Counsel, if there's a problem with any witness, please let us know. Dominion Energy, South Carolina.
Matt Gitson-Danner on behalf of Dominion Energy, South Carolina.
Thank you. Duke Energy Carolinas, Duke Energy Progress.
Heather Shirley Smith on behalf of Duke Energy Carolinas and Duke Energy Progress.
And Ashley Cooper on behalf of Duke Energy Carolinas and Duke Energy Progress.
Thank you. South Carolina Appleseed Legal Justice Center.
Good morning, Madam Vice Chairman. Adam Prothero on behalf of South Carolina Appleseed.
Thank you. Nucor Steel, South Carolina.
Good morning, Madam Vice Chair and members of the Commission. Rob Smith with Moore & Van Allen, representing Nucor Steel, South Carolina.
Thank you. Vote Solar.
Good morning, Madam Chair. Thad Cully on behalf of Vote Solar, joined by Beth Durant, Sal Durant.
Thank you. North Carolina Sustainable Energy Association.
Good morning, Madam Vice Chair. Bedford on behalf of North Carolina Sustainable Energy Association. With me is local counsel Jeff Kirkendall.
Thank you. Solar Energy Industries Association.
Jeff Kirkendall for Solar Energy Industries Association.
Thank you. Upstate Forever, CCL, SACE.
Good morning. Kate Lee here on behalf of South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever.
Alder Energy Systems.
Good morning, Madam Vice Chairman. Taylor Spear of Turner Paget, present for Alder Energy Systems, LLC. We appreciate you having us this morning. Thank you.
Thank you. Office of Regulatory Staff.
Good morning, Madam Vice Chair. Jenny Pittman and Jeff Nelson for ORS.
Thank you. Council, I'd like to alert you to some scheduling this morning. We have I'm not sure what that was. We have a commitment that couldn't, despite best efforts, could not be changed. So we're going to need to take an early lunch from about 11:30 until 1 o'clock. So we will try to go through from now until about 11:15 or so without a break. However, I have a caveat that always to defer to the court reporter because she's working hard and having to repeat everything, and sometimes she needs a break, so I always have to make sure about that. And I do apologize to the parties. This was something that just could not be changed despite best efforts. But so we'll go until about 11:15, and then come back at 1. And I hope that does not inconvenience you too much. With that, I will recognize Alder Energy and Mr. Spear.
Thank you, Madam Vice Chairman. If it pleases the Commission, Alder Energy will ask Mr. Donald Zimmerman to the stand.
Let's see. Do we have Mr. Zimmerman on camera?
Yes, good morning. Can you all hear me?
Good morning. Please state your name for the record, please.
My name is Donald R. Zimmerman.
Thank you, and the court reporter will swear you in.
You solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you very much.
Please proceed,
Mr.
Mr.
Zimmerman, what is your
Go ahead, I'm sorry. Please proceed.
Mr. Zimmerman, what is your full name and business address?
My name is Donald Zimmerman, Donald R. Zimmerman, business address 495 Jessen Lane in Charleston, South Carolina, 29492.
Who is your employer?
I am the president and CEO of Alder Energy Systems.
And what does Alder Energy Systems do?
Alder Energy Systems is a developer and EPC. It's a engineering, procurement, and construction contractor for solar energy systems in South Carolina as well as up and down the East Coast.
How long has Alder Energy been installing photovoltaic systems?
We have been operating for 12 years in South Carolina.
Excuse me, Mr. Spear. Mr. Zimmerman, we're having a little bit of difficulty hearing you. Can you get any closer to your microphone, please?
Oh yeah, you know, the mic's on the phone actually, and the phone is right up against the computer. I will, is that any better?
Yes, sir, that does help. Thank you.
Okay, I will try to direct my voice at the phone.
Mr. Zimmerman, will you please tell the Commission some examples of Alder's solar projects?
Alder Energy has installed projects anywhere from 2 kilowatt residential systems all the way up to an 8 megawatt utility scale system that's on a customer premise. That's the Volvo job in Ridgeville.
Can you give us an idea of how many behind-the-meter projects Alder has installed?
We've done almost 500 projects, of which about 800 are C&I or non-residential. I'm sorry, did I say 800? 80, excuse me.
Please tell the Commission what your educational background is.
Sure. I have an undergraduate degree in electrical engineering from the University of Michigan. A graduate degree in optics from the University of Rochester, and a graduate degree in business administration from Columbia University.
How about your professional experience?
I am NABCEP certified, NABCEP professional PV installer certified. It's NABCEP stands for North American Board of Certified Energy Practitioners. It's a very challenging credential to achieve. I was the second one in the state to achieve that. I am also the qualifier, that's the term, qualifier for our contractors licenses. We have both an unlimited general contractor's license and a unlimited electrical contractor's license in the state of South Carolina.
Have you ever, go ahead.
I have been operating in the technology world, particularly in photonics technology, for over 30 years, and I've got over 12 years of experience in working on PV systems, closer to 15. I also have 7 patents to my name. I used to do a lot of work in research and development.
Has Alder Energy or have you individually ever participated in solar policy in South Carolina?
I have attended a number of stakeholder meetings prior to Act 236 being implemented, and then post-Act 236 participated in the recap the recap work that was done by ORS to report back to the legislature on the effectiveness of that act. In addition, I have also worked with some stakeholders, particularly Duke, for their Act 62 community solar stakeholder meetings, in their community solar stakeholder meetings.
has Alder Energy ever intervened in a Public Service Commission proceeding?
We have not.
Has Alder Energy or any member of Alder Energy prior to this proceeding ever offered testimony in a Public Service Commission proceeding?
No, we have not.
Is Alder a member of any trade association groups related to the solar market?
Yes. We are a member of the South Carolina Solar Council. I was a board member from 2011 to 2018. We currently have another gentleman, Craig Knowlton, who is a current board member. We are a member of the South Carolina Solar Business Alliance. I was a board member from 2014 to 2018. And we have another member of our staff, Jared Branham, who is currently on the board. We're also members of SIA and the CSA, which is the Coalition for Community Solar Advocacy.
Did you file in this case 13 pages of direct and rebuttal testimony?
Yes, I did.
And you caused that to be filed under your direction, correct?
That is correct.
Madam, just as far as background here, the reason that I'm including direct and rebuttal together is that Alder Energy was permitted to intervene by a written order on the day that actually rebuttal testimony was due. So just for context, that those two things were filed together. Mr. Zimmerman, do you have any changes or corrections to that testimony?
Yes, there was one typographic error on page 3, line 1. Code reference should read 58-40-20A, not 41-20A.
If I was to ask you all of the questions that you were asked in your pre-filed testimony again today, as if you were on the stand and under oath, what would your answers be? Would they be the same?
They would be the same, yes.
Madam Vice Chairman, I move that the pre-filed testimony given by Mr. Zimmerman be entered into evidence in this proceeding.
Mr. Zimmerman's pre-filed testimony will be into the record as if given orally from the stand.
Also, Madam Vice Chairman, for context, there were exhibits that were attached to Mr. Zimmerman's testimony, but Alder believes that we've gotten the information that we need to that, so we will not be moving into evidence, at least in this proceeding, the exhibits that were previously identified as DRZ2 and DRZ3, but DRZ1 marked for identification purposes has already been admitted.
Thank you.
Mr. Zimmerman, I want to ask you if you prepared a summary of your testimony.
Yes, I do have a summary. I'm happy to read that.
Please do. Thank you.
Okay. Good morning, Madam Vice Chairman. My testimony is intended to assist the Commission in establishing net energy metering policies for South Carolina's commercial and industrial customers that comply with the Energy Freedom Act. I have been offering behind-the-meter solutions, solar solutions, to South Carolina ratepayers for over a decade. My company, Alder Energy Systems, has seen all manner of behind-the-meter policy changes, from SC PACE program to the utility rebates and incentives for net metering under Act 230, and now facing additional changes coming from this docket and others pending before the Commission. Alder Energy is currently South Carolina's leading provider of customer-generated solar for the commercial and industrial customer. Alder Energy's clients are small businesses, commercial real estate owner-developers, manufacturing plants, municipalities, and other non-taxable entities like schools and hospitals. These organizations all wish to participate in distributed generation solar to the extent that it is economically feasible. Alder Energy is the only testifying intervener in this proceeding that represents this market space. It is also the only solar developer that has intervened in its own name. I hope to offer the Commission a unique, boots-on-the-ground perspective and be the voice of non-residential customers that have or will invest in customer generation. Act 62 requires that the Commission determine the value of customer-generated solar in South Carolina and use those inputs to establish a successor tariff for net metering to replace existing policies. The Commission's decision will have a major impact on Alder Energy's clients and whether or not they choose to support their business with behind-the-meter solar.
Mr. Zimmerman, I apologize for interrupting, but you're getting lower. We need to speak.
Okay. Usually this speakerphone's not a problem. Okay. I will do my best to
That's better.
point in that direction.
That's a lot better. Thank you.
Okay. Let's see. The Commission's decision will have a major impact on Alder Energy's clients and whether or not they choose to support their businesses with behind-the-meter solar. The Commission's decision in this proceeding will decide the fate of an entire market sector of customer-generated solar in South Carolina, not to mention the fate of Alder Energy's 15 employees. The Commission should not underestimate the social cost of its decisions for a new net metering tariff. In determining the value of customer-generated solar, Act 62 directs the Commission to consider, first, continuing private investment in customer-generated solar. Second, reducing regulatory burdens to customer-generated solar. Third, avoiding disruption of customer-generated solar markets. And fourth, not penalizing customer-generated solar in South Carolina in doing so. I believe the utilities' proposals for valuing solar heavily weight eliminating cost shifting at the expense of the above market factors. While cost shifting should be considered by this Commission, it is only one of many factors. There is no suggestion in Act 62 that one factor should be given more weight than any other. The utilities and interveners in this case have proposed that the Commission adopt the value of net energy metering methodology approved by the Commission in the proceedings relative to Act 236. I do not oppose this methodology, but disagree that the value stack should maintain zero values for any elements of value provided in this methodology. The Commission should scrutinize the utilities' request to assign a zero value to the value of solar for any elements in the value stack. The utilities' proposals further fail to make meaningful distinctions between rate classes. The relative penetration of customer-generated solar in residential and non-residential rate cases is substantially different. The utilities' analysis fails to take this disparity into full consideration. For example, Alder Energy's average system size exceeds 100 kilowatts, but Duke Energy only modeled an 8 kilowatt system. Duke Energy and other interveners recently announced a settlement for a successor net metering tariff. It makes little mention of non-residential net metering and only provides for a non-residential offering with very few details. In sum, Alder Energy requests that the Commission approve a value of solar that incorporates the unique elements of non-residential customers' needs and different billing methodologies. The utilities' focus has been on residential net metering, but non-residential is an important market for South Carolina customers. Commissioners, when my examination is finished with the lawyers, I invite you and encourage you to direct any questions that you may have to me. Anything you have about how all of this works and from a solar developer's perspective. Thank you.
Thank you, Mr. Zimmerman. I'm going to continue to ask you a few questions, but I want to make sure that you don't have any notes in front of you or anything that you're referring to right now, correct?
No.
All right, thank you. Mr. Zimmerman, what are the drivers of net energy metering and customer generation for Alder's C&I customers?
Well, our customers consider many issues when they make a decision to go solar, not the least of which is the economic benefit that it will provide to them. They want to reduce their operating expenses, but at the same time, they also want to improve their resiliency of their electrical service, and they also want to meet climate management or climate change needs, and any kind of corporate mandates that might exist to reduce their net energy usage or to improve their use of renewables.
Madam Chair,
Mr. Zimmerman?
Madam Chair, this is
Hang on,
actually
just a moment, please. Hold on. Both of you, I've got the court reporter. Hang on a minute. Mr. Cooper?
I just have a question for the chair, just so we're clear about the record, Madam Chair. My understanding is Mr. Zimmerman has pre-filed his direct testimony. Is he changing his testimony? Is this correcting something in his testimony? Because I believe he's already pre-filed his direct testimony.
Mr. Spear, do you have a response?
I do. He's going to continue to talk about some of the things that are in his direct testimony and provide the commission context of what his market space looks like. I think that should certainly be relevant. We're not going to go on for half the day, but I certainly think that it's important to for the commission to hear from somebody in this case. And if Alder Energy wants to do some of that orally, I'm not aware of a rule that's prohibiting that. I've already established that I would think that this would be somewhat unfair if Mr. Zimmerman was simply going to read off of his notes. But as I've already clarified in the testimony under oath, this is nothing but his lawyer and his experience talking.
Madam Chair, this is Matt Gissendanner from Dominion Energy. I support the objection of Mr. Cooper. Mr. Spear just indicated that his client was providing additional context, which apparently is not in his direct testimony. He's already provided a summary, and the rules of the commission are clear that we provide pre-filed direct testimony. We don't add to our direct testimony by further oral testimony upon questioning by counsel at the hearing. So he's provided his summary. He should be subject to cross and questioned by the commissioners.
And to respond to that, Madam Chairman, we have no intent to go outside of the bounds of anything that was contained in our direct testimony. Again, this is to provide information orally to the commission. We are not straying from the confines of our written pre-filed testimony, but I think that the commission might want to hear from someone who is actually boots on the ground for this in this industry.
Mr. Spear, I will give you, you can continue your questioning, but it must stay within the bounds of the pre-filed testimony. If additional information comes out pursuant to cross-examination, you have an opportunity on redirect. But our direct testimonies need to be within the confines of the pre-filed.
That is understood, Madam Vice Chair, and we will certainly honor those rules.
Mr. Spear, just another thing. Mr. Zimmerman, I apologize, but we're still having difficulty capturing your testimony on live stream and the court reporter. Is there a handset that you can pick up and?
I was just thinking I'll use the handset. Is this any better?
Can you do a test 1, 2, 3 for me?
Yeah, test 1, 2, 3.
That's much better. Thank you very, very much.
Okay.
Permission to proceed, Mr. Chairman.
Please go ahead, Mr. Spear.
Mr. Zimmerman, you have just outlaid some of the goals that Alder's clients have in investing in customer-generated solar. How does Alder's customers achieve those goals under existing NEM policies?
Well, under existing NEM policy, they are compensated for the energy that they use or they consume behind the meter. They get credited at a retail rate. For For anything that gets exported, they are compensated also at the retail rate, given there is a one-to-one net metering policy in place right now.
How does system size impact the one-to-one net metering, if at all?
One-to-one net metering applies to all system sizes up to the allowed sizes. In general, the return on investment for a project is better for a larger system size. Most customers would like to achieve a 100% offset if that is physically feasible or feasible based on the rules of the program.
Does the system size or and its relevant offset impact the payback period that Alder's customers can see from installing customer-generated solar?
Absolutely. Given the larger the system size, the better the return on investment, the shorter the payback interval. Our customers will generally only sign a contract if paybacks are within the range of 4 to 7 years. We have never sold a project longer than 8 years. Actually, I don't think we've sold an 8-year payback project.
Are Alder's clients incentivized to size the system above and beyond 100% offset?
No, above 100% offset in the current regime, they are only compensated for at a avoided cost rate, or I should say, I believe it's a value of solar rate, which is equivalent to avoided cost, and that is economically not beneficial to the customer.
Do you have any experience or opinion as to what might happen to that payback window if the commission were to move beyond a 1-to-1 net metering ratio?
The lower the compensation rate for export, the worse the return on investment and the longer the payback interval will become. Right now, most systems, commercial space, are in the 6 to 7 year range. We have done some as low as 4, depending on which rate they're on. But if you change that export compensation, that will push the payback a number of years out, and it will significantly reduce the number of solar customers, C&I customers, that will install projects.
Were you present during Lon Huber's testimony yesterday from Duke Energy?
Yes, I was.
Do you recall his testimony that Duke Energy had modeled system payback in the event that the commission approves the proposed settlement terms?
Madam Chair, this is Ashley Cooper again. I don't understand how this is in the confines of his direct testimony that's been filed.
That's correct.
Madam Vice Chairman, what we're talking about here is the economic impact on payback period, and Mr. Huber estimated that under the existing proposed settlement terms that payback period would move to 14 years, and Mr. Zimmerman has just testified that...
Okay, we're getting a lot of interference. I don't know where that's coming from. Somebody doesn't have a microphone muted or something. Okay, Mr. Spear, I'm sorry. Mr. Gissendaner.
Madam Vice Chairman.
Or who was that?
Madam Chair, again, I would support the objection raised by Mr. Cooper, and if Mr. Spear would like to point us to the portions of his pre-filed testimony that reference Mr. Huber's testimony and Mr. Zimmerman is referring to, he's welcome to do so.
Okay.
Madam Chair, I would, while Mr. Spear is doing that, I would just point out that the commission set a procedural schedule for all parties. All parties submitted direct testimony, all parties submitted responsive testimony. This isn't about denying a witness an opportunity to present. It's just about treating all witnesses and respecting the regulatory process established by this commission. This is how all witnesses have proceeded. They submitted their direct testimony, and then they offered themselves to cross and questioning by the commission. That's all we're trying to do, and it's important to follow these regulatory processes so we have a complete and accurate record.
Madam Vice Chairman, Mr. Huber's testimony about the payback period was newly raised yesterday during my cross. It is in any of Mr. Huber's direct or rebuttal pre-filed testimony because it's new testimony. I would ask that the commission permit Mr. Zimmerman to advise it on his opinion as to what he believes will happen in his market space in the event that Lon Huber's projection becomes a fact.
And Madam
Okay.
Chair, Madam Chair, this is Ashley Cooper, and I'll be brief. So with that, then, would the chair be proposing to ask Mr. Zimmerman to allow Duke Energy to recall its witnesses, Mr. Gissner to recall its witnesses, or us to recall? I mean, where do we go from here?
We're going to take, I do recall in Mr. Zimmerman's testimony that he was talking about the payback period. And to the extent that he is responding to something that was elicited on cross yesterday, he can respond briefly. But Mr. Spear, let's rein this in.
Yes, ma'am. And that's just one question to Mr. Zimmerman. Do you have an opinion on what would happen to Alder's C&I market space in the event that Mr. Huber's projection of moving the average payback period from 11 to 14 years, how will that impact your clients?
As I previously said, we've never sold a system with a payback interval above 8 years. If we added 3 years to our current payback periods, that would put it outside the 8 years, and we would probably not sell a system.
Mr. Zimmerman, we're going to move quickly through the remainder of your testimony, and I do want to get out some important points. Have you ever had an example with a client that wanted to achieve 100% offset with a customer-generated asset in Duke territory but was unable to?
Yes. We had a client that they were a textile factory, and they wanted to offset 100% of their their annual energy usage. We calculated that the appropriate system size would have been a 600 kilowatt solar system, would have met their 100% energy offset requirement. We contacted Duke Energy. Duke Energy indicated that we could only build a 216 kilowatt system, and the client then basically declined to go forward, and to our knowledge has not gone forward with anyone.
Why was that client not able to achieve the offset?
They were not able to achieve the offset because their contract demand was 216 kilowatts, and that was, according to Duke, a limit that was on their system.
Because
Madam Chair, this is Ashley Cooper. Is this example of a textile company in his Mr. Zimmerman's direct?
There is discussion.
Yeah, it absolutely. Yeah. I'm sorry.
Go ahead, Mr. Spear.
I have nothing to add. Well, it certainly is in the testimony if I need to respond, and I can direct Mr. Cooper to where that is.
I believe it's on page 11 of, I don't know that he called it a textile company. I think it was referred to as a large commercial entity.
Mr. Zimmerman, we can shortcut this. Don't describe, please, this client in any more specificity than an industrial customer.
That's fine.
Okay. We understand the facts, but what is it in Duke's implementation of NIM policies specifically that precluded this customer?
Duke has chosen to limit system sizes to the contract demand amount and is not allowing any project to be built greater than that size, which in all cases we have found when you limit solar project to its contract demand, you cannot do greater than 50% offset, not 100% offset.
Did you review the pre-filed testimony offered by the utilities in this proceeding?
Yes, I did.
Did you identify any irregularities in their modeling?
In Duke's forecast modeling, they only considered 8 kilowatt systems, which are indicative of residential sizes. Our average size system is 114 kilowatts for the commercial space. In addition, they threw out customers with less than 50% offset out of their data set.
Did you identify any irregularities, in your opinion, in Dominion's forecast for C&I solar?
Dominion's forecast included, I believe it was 4 different C&I rates in their analysis, and they predicted a very small growth rate, only 11.5 megawatts across the C&I space over 10 years. That accounts to less than 2%, 0.2% of market penetration, 0.2% of system load.
Are you aware that the Duke Energy companies are likely to soon ask the Commission to approve a proposed settlement between them and a number of the other interveners in this case?
Yes, I am.
When did you become aware of that?
I became aware of that when I read about it in one of our trade emails. I believe it was Green Tech Media.
Have you reviewed the proposed settlement terms, the executive summary that is now an exhibit in this proceeding?
Yes, I've reviewed the executive summary, yes.
Have you identified anything in it that gives you concern from a C&I perspective?
Yes, in C&I, they had one bullet item representing what C&I was going to be. It was very vague, and there was no information effectively as to what that C&I solar choice rate would be or tariff would be.
Can you offer any additional details on how non-residential is handled in the proposed settlement terms?
What was in there, they indicated they would go from a annual netting to a monthly netting, and they would stay on the existing rate structure. And that, I believe, was the extent of the information that was provided.
In a residential context, how do residential customers with the customer generation asset proposed settlement terms get paid for exporting to the grid?
Right, and I believe that was also applied. They had indicated they would compensate at after the netting at avoided costs, not the value of solar.
What can this commission do in this proceeding to continue to grow C&I customer-generated solar in the state of South Carolina?
Well, based on the very low predicted growth in C&I and the very small market penetration, less of about 0.2%, and I believe Duke is comparable to the Dominion. I believe that the current one-for-one net metering tariff should be continued until the point in which the market penetration causes a material cost shifting. At the current time, I believe that it is very small and inconsequential. I also believe that customers should be allowed to offset up to 100% of their annual energy usage up to 1 megawatt. And I would like to see that continued going forward, or like to see that implemented going forward.
Thank you, Mr. Zimmerman. I appreciate you having a discussion with me about this. Madam Vice Chairman, at this time I would offer Mr. Zimmerman up for cross-examination, and Mr. Zimmerman, please answer the lawyer's questions honestly, to the best of your ability, and certainly communicate with the Commission on any questions that they would have. Thank you.
Absolutely will. Thank you.
South Carolina Appleseed Legal Justice Center, any questions?
No questions for this witness. Thank you.
Nucor Steel, South Carolina, any cross?
No cross, Madam Vice Chair.
Vote Solar?
Madam Vice Chair, yes, I do have questions.
Please proceed.
Okay, good morning, Mr. Zimmerman.
Good morning,
Thad Cully with I'm Thad Cully with Vote Solar, and I'm also going to join you at the headset so we can have a very public phone conversation.
Great.
So, Mr. Zimmerman, in your testimony, you state that you started your company in 2008, and that's correct?
Yes.
And at that time, had South Carolina adopted net metering for the first time?
Net metering was in place at the time I started the company, yes.
Okay. Now, have you heard the term used in the solar industry, the solar coaster?
Yes, we use it regularly.
And as a business owner, you'd agree this is not a fun ride to be on?
It is very challenging business to be in.
And to explain for the Commission, we use a joking term like solar coaster. Would you agree we're talking about periods of growth with supportive policy, then running into an absence of policy and seeing a market plummet, and then a policy correction and policy growth again? And would you agree that is generally what we refer to as a solar coaster?
Absolutely. The landscape in which you are operating is constantly shifting beneath you, and such as tariffs, tax credits, regulatory policy, or they're constantly changing, and you have to be very adaptable.
Right. And in your time operating a business in the state of South Carolina, have you been on a ride like this? Have you seen the ups and downs of the solar coaster?
Absolutely.
Now, you mentioned having some work with stakeholders prior to 36 in 2014.
Mm-hmm.
Were you at that time, actually, was there a Solar Business Alliance in existence at that time?
I believe it was just getting started at that time. I can't tell you exactly.
And would you agree with me that organizations like Solar Business Alliance and some of the other organizations you mentioned in your direct testimony here today include a lot of companies like yourself that aggregate their resources to participate in the policy sphere, be it at the Commission or in hiring a lobbyist to participate in policy at the legislature?
Yeah, well, certainly the SBA currently does that. Solar Council does not really get involved with policy.
And so from a standpoint of a small business, and I understand you have 15 employees, is that correct?
Yes.
Participating in the regulatory process is unfortunately a pretty expensive endeavor. Would you agree?
Terribly expensive, yes.
Right, and we appreciate you being here. I think it speaks to the importance to you of having your voice heard. So thank you for being here. But given the expense of participating in the regulatory process, would you think it is reasonable as a small business owner to rely sometimes on a business trade organization to represent your interests there?
I think it is in many cases one of the best options because of the point you made of pooling resources. As you well know, getting involved in policy issues is a very expensive endeavor, and if that cost can be shared amongst stakeholders that have a similar interest, it absolutely is the best way to go.
And as a member of an organization like that, you're always free to step out on your own and exercise your free speech and your advocate for your company's specific interest, right?
Absolutely.
Right. Would you agree that there may be other companies similarly situated as yours, focused on commercial industrial, that are relying currently on some of these other organizations to represent their interests before the commission?
I believe that there are other organizations such as mine that are doing C&I. As to whether they are relying on other organizations, the few I know that are out there are not members of the organizations I'm aware of that are doing policy work.
Okay, no, that's a very fair point. And also, when we think about legislative work, would you agree that legislative advocacy in South Carolina has been really important for the growth of the solar industry?
Absolutely critical, because without the legislative intervention, these regulations and rules would not be in place.
Right, thank you. With Act 236 in particular, there was, I think you mentioned some pre-Act 236 stakeholder work before that bill was final. And then you also, I believe, referenced implementation work and further stakeholder work on that. Am I recalling your statement?
Yes.
Okay. So you're aware when a piece of legislation like Act 236 went in, there'd be a lot of work to do to hammer it out at the Public Service Commission.
Yeah. Yes, I'm sure there is.
And with Act 236, when we go back to our idea of the roller coaster, would you agree with me that Act 236 provided a bit of a limited runway for solar growth when we talk about the rooftop and behind the meter space, because it had a 2% program cap? 2% of the utility peak was the total program capacity. Would you agree that there was a limited program in Act 236?
Yeah, there were some guardrails put on that, and there was a cap that was in place. And at the time, we had envisioned that cap giving us a little bit more runway than it did.
So we might still be here in 2020 if we had our hindsight on. We may not picture ourselves on a WebEx, but we may picture ourselves in 2020 discussing a successor policy to the Act 236 net metering. Is that consistent with your understanding of those conversations?
Yes, I mean, we certainly envisioned in Act 236 that there would be some follow-on discussions, be it legislation or additional regulatory work to be done.
Okay. Now, in 2018, was there a worry within the solar industry and for you personally with your business that the utilities were fast approaching their program caps and that this policy that had been so important to your business might be going away?
Yes, we were concerned that we would hit the net metering cap and there would be no successor, and it would be a cold turkey. I mean, I'll be truthful, I was implementing plans for layoffs if that happened. It luckily didn't.
And that's as a business owner, a terrible place to be. You would agree?
It is an awful to be, and I've unfortunately had to do it a number of times in this and previous roles, and it's never fun.
Now, in the 2018 legislative session, were you aware that there was a bill introduced and made it pretty far in the process in the House that would have lifted the net metering cap?
Yes, I was following that.
Right, and that bill was that House Bill 4421. Maybe you don't remember the exact number, but
sounds familiar.
Subject to check.
But yeah, I can't swear to that.
Okay, and do you recall if that bill would have kept status quo net metering as it was under Act 236, or did it have some modifications?
I really can't recall that bill in that detail right now.
Okay, would you accept, subject to check, that it would have moved from an annual netting period to a monthly netting period? Does that sound familiar in your conversations at that time?
It does not sound familiar to me. I'm sorry.
Okay, no problem at all. Well, let's take this a different way. Currently, net metering applies to a variety of different customer rates. Would you agree with that?
Yes, sir.
So the process of taking whatever is put to the grid from a solar facility and netting that against what the customer is drawing from the grid in that time period, that can be applied to residential rates, to commercial industrial rates, to virtually any rate where a customer is allowed to install the solar. Is that consistent with your understanding?
Yes, that's right.
And are you aware that the underlying rates are subject to change in general rate cases that the utility bring from time to time?
Yes.
And do you understand that those changes in rates may affect the value proposition even if you kept annual netting, that the change of rates may also affect the value proposition?
Absolutely, yes. It could change in either direction.
Right. And again, as a solar company that has an interest, direct economic interest in the outcome of policy, I think I just listed one more docket that you might have to be involved in. And would you agree that that's just too much for one company to be a part of?
We have to be very careful on how we spend our money, and yes, we don't have the ability to basically get involved with every docket.
And I'm going to wrap up here. I think we've really appreciate your answers. But I do want to ask one thing. Now, you've heard some testimony in this docket, I presume, with witness Robinson from Dominion Energy, South Carolina, and the solar forecast, and as well there were some counterparts at Duke that had similar testimony about projections. From your perspective, you've talked to customers, you know the appetite that's out there. Do you see the market potential in South Carolina for C&I as being appreciably higher than what has been discussed so far?
In the last year, I would probably say their forecasts are right. 2020 has been awful. Prior to 2020, I would say I believe they're slightly low. But I'm not a forecast expert.
Right, but I think you've identified there's an asterisk on everything we're doing this year.
Unfortunately, yes, it makes our vision. The vision in the solar industry is very hard to come by anyway, but it makes it very hard to forecast.
And so, Mr. Zimmerman, of the 15 employees you have now, do you have a vision for how big you'd like to grow your company in South Carolina?
In South Carolina, we would love to be able to grow at a very nice clip, basically as the market grows, and maintain our market leadership. That is really a lot of it is policy driven. The growth rates in other locales are much greater, and I would hate to see anything done in this regulatory body or in the legislative body that would stifle that growth.
And do all of your employees live in the state of South Carolina?
All but one.
And one last question. I'm sure you're familiar with Dr. Hefner's testimony in this case with the economic impact study. Now, he referenced an annual survey called from the Solar Foundation, the Solar Census. Mm-hmm. Have you ever received that solar census to fill out?
Yes, I have received it. I believe I filled it out a couple of years ago. I know the last one or two times that it came in, I never got it out again.
Okay, so you would agree that with a survey like that of the solar industry, you're very busy. There's a possibility you may have missed it one year. There's probably other companies may have missed it one year.
Right.
But
we did participate in it a couple of years ago.
Okay, would that be 2018?
Probably.
Okay, or 2019? Those are the years Dr. Hefner was basing his
analysis. I'm not sure about
on.
2019, and I don't believe I've seen it in 2020 yet.
Okay. No, thank you. That's very helpful. I appreciate your time today, and thank you for being here. I have no more questions.
Good. Thank you.
Thank you, Mr. Culley. North Carolina Sustainable Energy Association, any cross?
Madam Chair, this is Peter Ledford with the North Carolina Sustainable Energy Association. Just a couple of questions for Mr. Zimmerman.
Go ahead, please.
Mr. Zimmerman, on page 3 of your testimony, you state that on information belief, no other intervener in this proceeding will actually represent the interests of C&I customers or otherwise offer testimony on their behalf.
Yes.
Are you aware? I'm sorry. Are you aware what businesses are members of NCSEA?
I am not a member of your organization, so I really don't know who your membership is.
So are you aware that NCSEA's membership includes C&I installers of C&I rooftop solar?
I would assume they would, but once again, I don't know much about your organization.
And are you aware that NCSEA's membership includes C&I customers that have adopted rooftop solar?
I'm not aware of that.
Okay. Thank you. That was all I had.
Thank you, Mr. Ledford. Solar Energy Industries Association, any cross?
No cross from TA, Your Honor.
Upstate Forever CCL SACE, any cross?
We have no questions. Thank you.
Dominion Energy South Carolina, any cross?
No cross for this witness.
Duke Energy Carolinas, Duke Energy Progress, any cross?
Thank you, Madam Chair. This is Ashley Cooper on behalf of Duke Energy Companies. I have a few questions for Mr. Zimmerman, if I may.
Please proceed.
Good morning, Mr. Zimmerman. Again, my name is Ashley Cooper. I have just a couple of questions I want to run through based on your pre-file testimony and also your testimony this morning.
Mr. Cooper, I apologize for interrupting, but if you could adjust your volume, it would be helpful.
I'll move my phone as well. Is that better, Madam?
Can you give me a test, please?
Test 1, 2, 3, 4. Test 1, 2.
Can you get any closer?
I think so. Test 1, 2, 3. Test 1, 2, 3.
That's a little bit better. Thank you.
Thank you. Okay, good morning, Mr. Zimmerman. I have just a couple of questions for you. I want to start with some of the questions you just answered a second ago when you were talking about some of the growth and I guess the solar coaster that you described. Your business is located in the city of Charleston. That's where you're headquartered, correct?
Well, we have a Charleston address. We are located in Berkeley County, which is what's the phrase? It's unincorporated here.
Okay, I understand. Are you aware of a government program by the city of Charleston that helps hotel developers smooth out the ups and downs, the growth and the expansion for developing hotels in downtown Charleston?
No, I'm unfamiliar with that.
Would you think that hotel developers would want to grow at a, quote, nice clip?
Of course.
Okay. And when you say that you would like to grow, quote, at a nice clip, are you advocating on behalf of Alder Energy, or are you advocating on behalf of C&I customers?
Well, I'm advocating on behalf of both. Alder Energy benefits from when C&I customers adopt solar, and I started the business to promote the adoption of solar and to help in that regard.
Okay. Thank you. Okay, I'd like to turn back. I think you got a question just a second ago along these lines, but on page 3 of your testimony, lines 9 and 11, you say no other intervener in this proceeding will actively represent the interests of C&I customers or otherwise offer testimony. I want to talk to you a little bit about the interveners. Are you aware that the Solar Energy Industries Association, known as SEIA, has intervened in this docket?
I am aware now, yes.
Okay. Are you aware that they intervened approximately 6 weeks before you did?
It's possible. Sure.
Okay. And you're a member of SEIA, that's correct?
Yes.
Okay. And on line 7, you talk about your concern of the representation of C&I interests in the Duke stakeholder process. Are you familiar with Gregory Electric?
Yes, I am.
And is that a fellow solar developer?
That's not their primary business.
Well, would they have an interest in C&I solar rates in South Carolina?
I would guess they would.
Okay. Are you aware that Gregory Electric attended both stakeholder meetings held by Duke Energy?
At the time of that testimony, I was unaware.
Okay.
I currently am, based on the exhibits that were provided.
Okay. Thank you very much. Are you aware that the South Carolina, or let me back up. Are you familiar with the South Carolina Energy Users Committee?
I've heard the name of that committee, yes.
And they represent commercial and industrial users in South Carolina.
I would assume, yes.
Okay. And are you aware that they participated in the first stakeholder meeting that Duke held?
I did not have access. I currently am aware of that because I have seen the roster from the exhibits, but at the time of my written testimony, I had not seen the exhibits.
Okay, thank you. And are you aware that Walmart Corporation participated in both stakeholder meetings?
Yes, I am now.
And Walmart would clearly be an C&I customer.
Yes.
And in fact, Walmart had 3 people participate in the first meeting. Are you aware of that?
I didn't count the number of people. I did see their name on the list.
And they had 2 people participate in the second meeting.
Okay.
And then, are you aware that a representative, at least one representative from the Office of Regulatory Staff, attended both stakeholder meetings?
I am now, yes.
And are you aware that the Office of Regulatory Staff is participating in this docketed proceeding?
Yes.
Okay. And are you aware that ORS has retained a recognized expert?
Yes.
Okay. And are you aware that the Office of Regulatory Staff, one of their charges is to represent all customers?
Yes, of course.
Okay. Thank you. Okay. So on page 7, lines 10 through 11, you state, on information and belief, no one discussed C&I solar successor rates, correct?
I need to see that testimony. Let me pull out my copy here. And can you give me the line and the page and line reference again, please?
It's page 7, line, starts on line 10, and it says, information and belief.
And is that the page number I have or on the filing page?
Yes, sir. Page 7 is the page number for your testimony.
Okay. And you said, on information belief, no one discussed. Okay. I see it.
Okay. But you are aware that there certainly were representatives of the C&I industry at these meetings.
I have been, yes, I am aware of that now.
Okay. I also want to be really clear about the process in Act 62. Are you aware that Act 62 established this docket, which is a generic docket? And the purpose of this generic docket is to investigate and determine the cost and benefits of the current net energy metering program and establish a methodology for calculating the value of solar. So this current generic docket is to have a look back at the current NEM program. Are you aware that that's the scope of this proceeding?
I believe that is, and where, I might ask a question if I could, where is that, where's that identified in the scope?
Yes, sir. I'd be happy.
Madam Vice Chairman.
Yes, Mr. Spear?
This is Taylor Spear for Alder Energy. I would object to the line of questioning as argumentative. The commission determines what is relevant in this proceeding. Mr. Cooper does not, and he is testifying as if it is him that outlines those boundaries.
I'm going to overrule your objection. This is cross-examination. Tough questions are not always argumentative, so Mr. Cooper, please proceed. Thank you, Mr. Spear.
Thank you, Madam Chair. And just to be clear, I just want to make sure we're all on the same page. It's really important to understand the scope of the stakeholder meetings and the scope of this docket. So back to Mr. Zimmerman, I'm just looking at the statute itself. It's section 5840-20, and then C, 1 and 2. C says it starts no later than January 1, 2020. The Commission shall open a generic docket 2.
Okay, well, I also see that on the top of our exhibits here, and I do see what you're saying there, and I believe the language is that you are using is correct.
Okay, and just out of convenience, I was going to go into this now, but just to make it easier for you, since you're there.
Mr. Cooper, you're facing away from your phone, I believe, and it's difficult to hear you. Do you have a handset? I know that's difficult to juggle a handset when you're juggling papers, but it might be the best remedy.
Madam Chair, I've just switched to a handset. Is this better?
That is much better. Thank you very much.
Thank you. And Mr. Zimmerman, just for your convenience, since you just read C, I want to go ahead just to make this easy. Could you look at and see where it says F1 and the first two words are after notice and opportunity?
Sir, I do not have the code that you're asking me to look at in front of me. I have just the header page to our exhibit submission is what I'm looking at.
Well, I'll tell you what. Let me do this. Let me read it to you, and if we need to stop and I need to email this to Mr. Spear, or if Mr. Spear can email it to you, I don't want you to be rushed. I want you to have a chance to look and make sure you fully understand what I'm reading and looking at. But let me just read this. F1 states, after notice and opportunity for public comment and public hearing, the Commission shall establish a solar choice metering tariff for customer generators to go into effect for applications received after May 31, 2020. And then it lists things that should be in the solar choice tariff.
Mr. Cooper, please reread that section.
Okay.
I
I'm
don't
reading
believe you
section-
read the date correctly.
Sorry, let me reread it. Section F1 says, after notice and opportunity for public comment and public hearing, the Commission shall establish a solar choice metering tariff for customer generators to go into effect for applications received after May 31, 2021.
Okay.
Mr. Zimmerman, are you aware of that? So that's a separate part that talks about a successor solar choice tariff.
Mm-hmm.
Okay, so that's different than the purpose of this generic docket. Does that make sense?
I understand that there are multiple dockets that have been created. I believe that this docket, as its second, to establish a methodology for calculating the value of energy produced by customer generators. And I believe that what we've been talking about is the value of energy that is going to be produced by customer generators.
Okay. Well, but what we've talked about, that's what you have been talking about, but the purpose of this generic docket is to talk about a methodology for calculating. And so this is really about looking at the existing NEM program. Any sort of successor solar tariff, which is what you're concerned about, is going to take place in a upcoming docket, a docket where we've, there's not even been a docket, I don't believe, established yet for Dominion, but there is a Duke utility-specific docket, which has not occurred yet. I just want to make sure we're clear about that.
Well, we are an intervener in that docket as well.
Okay. So we're clear that the purpose of this proceeding.
Mr. Spear,
Thank you. I object to Mr. Cooper telling Mr. Zimmerman what he is concerned about when his testimony has been clear that it's much broader than the limited frame that Mr. Cooper stated. Again, it's argumentative, and I believe it's unfair to the witness.
Mr. Cooper, I need for you to ask questions and not make statements, please, sir.
Okay. Thank you, Madam Chair. I'm just trying to establish what we're talking about here as opposed to...
Oh, yes, sir. I would prefer if you would ask questions and not make statements, please, sir.
Thank you, Madam Chair. Understood, and I apologize. Okay. Mr. Zimmerman, I know you indicated that you've never intervened in a proceeding before, but you are a member of the South Carolina Solar Business Alliance. Is that correct?
Yes, my company is, yes.
And your company is a, quote, active, unquote, quote, active delegate, unquote, in these associations. Is that correct?
We have a board member on the SBA, yes.
Okay. And is it true that the Solar Business Alliance has previously intervened in other dockets before this commission on behalf of Alder Energy?
The SBA has intervened.
Madam Chairman.
Is that Mr. Spear?
Madam Chairman, SBA enters in its own name, not on behalf of anyone else. That's a
Mr. Spear?
complicated and detailed process how that works. That's an argumentative question. It's not appropriate in Alder's view.
If Mr. Zimmerman doesn't know, he can say no. If he knows, he can say yes. It's a yes or no question. Please go ahead.
Could you repeat the question, please?
Yes. Isn't it true that the South Carolina Solar Business Alliance, has previously intervened in dockets before this commission on behalf of Alder Energy?
No.
It's not. Okay. Are you familiar with docket 2014-246E, where there was a joint statement, there was a joint settlement testimony from Paul Fleury and Grant Reeves on behalf of the Solar Business Alliance?
I am not aware of that particular number, and I don't have that document in front of me. I really can't comment on that.
Okay. Do you know Mr. Fleury?
Yes, I know of Mr. Fleury.
Okay. Well, in his testimony, Mr. Fleury was asked this question: who are the primary decision makers for the SC SBA? And his answer was the SC SBA is a managed LLC whose current managers include Mr. Fleury, Mr. Reeves, along with Andrew Street with Solbright, Don Zimmerman with Alder Energy. All of us conduct solar energy related business in South Carolina. So clearly this is indicating that the Solar Business Alliance intervenes in dockets and intervenes on behalf of its members.
Is that a
Do you accept
question?
that? Yes. Do you understand that?
Can you repeat the question in a different fashion, please?
Yes. That the Solar Business Alliance intervenes in dockets before this commission on behalf of its members.
I agree with that.
Okay. And you are a member of the South Carolina Solar Business Alliance?
Well, my company is a member, yes.
Your company. Is it reasonable to believe that the Solar Business Alliance would provide your company information about these dockets?
Yes, it is reasonable to assume that. And when you
Okay.
say these dockets, I need to understand which specific documents you're speaking of.
I would say a docket that directly impacts one of its member companies.
Yes, generally the docket framework is discussed at the board level.
Okay. And are you aware that Duke Energy invited the South Carolina Solar Business Alliance to attend or participate in its stakeholder meetings?
I'm unaware of that.
Okay. Okay. Are you aware that the commission has a docketing system where you can monitor a docket that's currently established before the Public Service Commission?
Yes.
Okay. And are you aware that there were notices provided in this generic docket that describe the stakeholder process?
I haven't read those notices.
Okay. Well, there were notices provided in the docket, and are you aware that you wouldn't have had to intervene to see and monitor the docket? Are you aware of that?
Yes, I am aware of that.
Okay. So that would have been another, let me ask you this, you could have found out about this docket, about these stakeholder meetings through the South Carolina Solar Business Alliance, correct?
We didn't.
But that's a possible avenue of information.
I don't know how to answer that question. There's a lot of things that are possible.
You're a member.
Someone from Duke Energy could have called me and said, "Would you like to participate?" I have participated in other stakeholder meetings.
I understand, and you made that point very clear. I'm just making the point there were multiple ways for Alder Energy to have known about these stakeholder processes.
If I had the luxury of time to pour through the public service dockets every day, you're right, I might have seen it, but I don't.
Well, isn't it true that if you just signed up for information about this docket, the Public Service Commission's docketing system would have sent you updating emails? So you wouldn't have to go
I am unaware that that exists.
Okay. Thank you very much. All right, I want to turn to a different topic. And I want to go to page 5, line 22, through page 6, line 3 of your testimony, where you talk about zero values, Mr. Zimmerman. So please take a second and let me know when you found that.
Okay, page 5, you had said?
Yes, sir.
All right, and that's my page 5.
Yes, that's correct.
All right.
And it starts on line 22.
Mm-hmm.
Let me know when you found it. It begins with the word however.
Yes, I've got it.
Okay, and say I However, I do not accept, nor do I believe Alder's customers will accept the utility's position that the Commission should maintain $0 values in any of the 11 methodology components.
Yes,
That's
sir.
your testimony, correct?
That's correct.
Okay. And Mr. Zimmerman, how much are the South Carolina utilities paying today for carbon dioxide emission costs?
I don't know.
Okay. Well, if you had followed the docket, docket 2019-3-E, you would see that the order of this commission says there's $0 cost for carbon dioxide emissions. Are you aware of that?
I'm unaware of that.
Okay. So you would, even that they are currently paying $0, you believe there should be some figure other than zero that's utilized in the components.
I believe that the cost to society is greater than zero.
Okay. Okay. I want to ask you about a couple of other things. The value of solar inputs, those are evaluated and set in fuel proceedings. Are you aware of that?
I am aware that fuel proceedings have an impact on that. I don't know where exactly those numbers are calculated.
Okay. And for Duke Energy, they've had fuel proceedings in 2017, 2018, and 2019, each of those years. Are you aware of that?
I was unaware that it was annual, but I know that it's on a regular basis.
Okay. And did you participate in any of those proceedings?
No.
Did Alder Energy, let me rephrase the question. Did Alder Energy participate in any of those proceedings?
Not as an intervener, no.
Okay. And you're aware that some of the values for the 11 components were established in these dockets?
I am not exactly sure where they are established, sir.
Okay. Okay, I now want to ask you about, if you would turn to page 4 of your testimony.
Okay.
Give me 1 second, my pages are... on page 4, going over to line 3 on page 5, you state that the General Assembly appears to have preferred expansion of customer-generated solar over cost-shifting considerations by enumerating more factors tending to grow DG penetration in South Carolina and less factors that would potentially limit growth, open parens subsidy. Is that correct?
I did not read. You just read me, so if we could start over again. You said it starts at line 22?
It starts on page 4.
Page 4, line 22. Is that where you started?
Yes. Let's see. That's right. Hang on 1 second. My pages have somehow appear to have gotten a little bit out of order here. I'll read it again. Okay. Yes, the General Assembly did not prioritize any one purpose of the provisions. Where I'm going is line 23. To the contrary, the General Assembly appears to, and then I pick up on the next page, which is page 5, the General Assembly appears to prefer the expansion of customer-generated solar over cost-shifting considerations by enumerating more factors tending to grow DG penetration. Is that your statement?
Yes, that's what I had written there, yes.
Okay. Okay. Now, are you aware that this is the actual words of the General Assembly and their directive to this commission when establishing a successor solar choice tariff? Their direction to this commission is eliminate any cost shift to the greatest extent practicable on customers who do not have customer-sited generation, while also ensuring access to customer generator options. Are you aware that those are the General Assembly's instructions or directives to this commission?
I believe there's other areas where they talk about the intent of the General Assembly is to, one, build upon the successful deployment of solar generating capacity through Act 236 of 2014, to continue enabling market-driven private investment in distributed energy resources across the state by reducing regulatory and administrative burdens, to customer installation and utilization of on-site energy resources, and two, avoid disruption of the growing market for customer-scaled distributed energy resources, and three, require the Commission to establish solar choice metering requirements that fairly allocate costs and benefits to eliminate any cost shift or subsidization associated with net metering to the greatest extent practicable. There are three intents listed in Section 584020, Section A, of which two of them talk about maintaining and growing the market, and the third one talks about cost shift, eliminating cost shift to the greatest extent practicable.
That's correct. Those are, I agree with you, those are the three general provisions. But I'm going to the specific provision, which is the directive of the General Assembly to this Commission when establishing a successor solar metering tariff. So I'd say this is a more specific directive, and I'll read that to you. G1 states, eliminate any cost shift to the greatest extent practicable on customers who do not have customer-sited generation, while also ensuring access to customer generator options for customers who choose to enroll in customer generator programs. Were you aware of that requirement and that instruction when you made your developed your testimony?
Well, I contend that access implies that you have a vibrant market with people that are able to deliver that capability. If you don't have a vibrant market, there will be no providers.
But
so access is the aspect I'm speaking of, sir.
So in your mind, does access, is that the same as prefer expansion?
Access means that you have a vibrant market where people can go and purchase from the market. That's what I believe access means. And there's no regulatory burden in the way, such as stated in their intent.
Okay. And so I want to go back to that. You mentioned, you read 584020A1.
Mm-hmm.
And
A1, 2, and 3, yes.
Yes, but I want to just talk about A1. And it says, build upon successful deployment of solar generating capacity through Act 236 of 2014 to continue market-driven private investment. Do you understand what market-driven means?
Yes, I believe I do, sir.
And you believe in a capitalist society, correct?
Yes, I do, sir.
Okay. Yet, you're advocating that this commission impose a one-for-one rate credit for surplus energy regardless of any measure of cost and benefits. Isn't that correct?
That's not what I said.
Right. Did you advocate that this commission impose a one-for-one rate credit for surplus energy?
Yes, I did.
And in fact, in response to your counsel's question about what do you want in this proceeding, which is a generic proceeding, doesn't have anything to do about a successor tariff, you said a one-for-one tariff must be continued. Isn't that correct?
That's what I would like to see, yes, sir.
Act 62 doesn't mandate that. Act 62 talks about market principles and a cost-benefit analysis. Isn't that correct?
That's of many things it talks about. It also talks about a successor tariff, and it doesn't say what that successor tariff is.
Okay, Mr. Zimmerman, thank you very much. You've been very patient. Madam Chair, I appreciate your patience as well. I have no further questions.
Thank you, Mr. Cooper. That's my list.
Madam Vice Chair, one last question. I recognize that's a lawyer's famous last words, but I'm going to really
Mr.
try
Spear, we're not back to you yet. We're not back to you yet.
I'm so sorry, Madam Vice.
That's okay. Hang on. Office of Regulatory Staff.
No questions from ORS.
Commissioners, any questions, Mr. Zimmerman?
Chairwoman Belser.
Commissioner Williams.
Thank you. Good morning, Mr. Zimmerman.
Good morning. How are you?
Good. I appreciated your background and references to Act 236 and both the creation of it and then the, I've forgotten the word you used, but kind of the assessment of how it was going. And as you know, I'm new, others are new, and we're trying to understand the context in which all of this has evolved. And so my question is, for Act 236 and the net metering, the original net metering docket, what was the framework in Act 236 and in what we currently work on with regards to commercial and industrial customers? Are they treated, were they statutorily treated, envisioned to be treated differently? Did we, from your knowledge, how were those treated as a part of the solar customers?
Well, so to my understanding, and I'll be very, very clear here. I am not an expert on either of them. I didn't draft them. I provided input and to frame them. What we're operating in an Act 236 environment is that commercial customers as well as residential customers both had one-to-one net metering, and they were basically treated the same. The only difference being the size limitations, and that a lot of that had to do with the way the different utilities treated the size limitations, and we only got into an issue on that in CNI.
And so you're speaking to how Act 236 was implemented?
Correct.
Okay. And then changing gears a bit, as you know, and as was discussed previously, the cost shifting or cost subsidization is a key element in Act 62. What is your position on cross subsidization as it relates to commercial and industrial solar?
Sure. Well, the impact to the customer base is very low when there's very low penetration. You know, I'll take Dominion right now as an example. Right now, Dominion has approximately 15 megawatts of CNI solar in place, and they're predicting it to grow by another 11.5 megawatts over 10 years. If you look at the percentage of penetration compared to the total load on the grid, currently it's about 0.2% of the grid, and will go up, correspondingly in over 10 years. But 0.2% of total load is an incredibly small fraction. What I haven't seen yet is an accurate accounting, if you will, of how much it truly costs to serve a CNI customer, and correspondingly what that cost shift is in terms of, every other CNI ratepayer, how much are they impacted? I mean, the math is, I don't believe that hard. It just needs to be done. And I think that that would be probably a good question to ask. And if I could, if you could simply say it's only a couple pennies per customer per month, you can gauge the impact to that customer. I contend, to your question, I contend that at low penetration rates, any cost shifting, which is modest in size, is offset by the benefit that the solar can provide on the grid and the direction we need to go.
Just to be really clear, what I think you said is right now you don't have the information about cross-subsidization within commercial and industrial accounts, and that's a number we should be exploring. Is that
Exactly.
what I heard you
that
say?
is fine.
Okay.
Yes,
Thank you very
that's
much.
my question. Absolutely.
Commissioners, any further questions? Mr. Spear, redirect.
Nothing for redirect from Alder Energy. Thank you, Madam Vice Chair.
Thank you. Mr. Zimmerman, thank you for your appearance this morning and for your testimony. You may stand down from the stand. Thank you.
You're quite welcome. Thank you. Have a great day.
Thank you, sir. Office of Regulatory Staff, I think we're to you now.
Thank you, Madam Vice Chair. At this time, this is Jenny Pittman for ORS. At this time, ORS would like to call Robert Lawyer to the stand.
That's fine. Do we have him?
In 1 moment, I think we will.
Thank you, ma'am.
I apologize, Madam Vice Chair. Brief technical difficulties.
That's fine. We've had them too. We understand. There we go.
We're all set. Thank you.
Mr. Lawyer, would you state your name for the record, please?
My name is Robert A. Lawyer.
The court reporter will swear you in.
Mr. Lawyer, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Go ahead, Ms. Pittman.
Thank you. Mr. Lawyer, please state your name and occupation.
My name is Robert A. Lawyer. I'm the Deputy Director of Energy Efficiency and Renewables for the Office of Regulatory Staff.
Are you the same Robert Lawyer who pre-filed 7 pages of direct testimony with this commission on October 8th, 2020 in this docket?
I am.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
No.
If I ask you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes.
At this time, ORS asks that the pre-filed direct testimony of Mr. Lawyer be read into the record as if given orally from the stand.
Mr. Lawyer's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you. Mr. Lawyer, did you prepare a summary of your direct testimony?
I did.
Will you please present it to the commission at this time?
Sure. Good morning, Madam Vice Chair, members of the Commission. The purpose of my testimony is to set forth and support ORS's review, analyses, and resulting recommendations in compliance with Section 5840-20C of the South Carolina Energy Freedom Act, or Act 62. That is to, 1, investigate and determine the costs and benefits of the current net energy metering program, or NEM,
And number 2, establish a methodology for calculating the value of the energy produced by customer generators. I also introduced 2 expert witnesses retained by ORS for this proceeding. First off, Dr. John Roof, the principal and owner of the Roof Group, and Mr. Brian Orey, a senior partner in Energy and Environmental Economics, Inc., or E3. Dr. Roof has over 40 years of experience in policy analysis and advocacy on energy and utility issues in South Carolina, representing customer interests before this commission, South Carolina General Assembly, as well as state and federal courts. Dr. Roof addresses and emphasizes the impact of cost shift or cross-subsidization of NEM customers by customers that do not want, and or cannot afford to install solar generation. Dr. Roof also discusses the economic characteristics of NEM customers, the energy burden experiences by low-income South Carolinians, and certain ways that low-income communities may benefit from access to solar. Mr. Brian Orey has in excess of 30 years of experience in the energy industry, with expertise in avoided costs, utility rate making, cost effectiveness evaluation, transmission and distribution planning, and distributed energy resources. Mr. Orey discusses E3's analyses and review pursuant to Section 584020C of Act 62 and presents recommendations for the Commission's consideration. He also will address how avoided and embedded cost of service should be evaluated and utilized in the development and design of the solar choice metering tariffs to be considered by this Commission in further proceedings pursuant to Section 584020F of Act 62. Based on the reviews and analyses of both ORS expert witnesses, ORS supports the 2 recommendations of Dr. Roof and 11 recommendations of Mr. Orey as presented in their respective direct testimonies. This concludes my summary.
Thank you. Madam Vice Chair, Mr. Lawyer is available for questioning.
Thank you, Ms. Pittman. Dominion Energy, South Carolina, any cross?
No cross for this witness.
Duke Energy Carolinas, Duke Energy Progress, any cross?
Madam Chair, this is Ashley Cooper. We have no cross.
Thank you. South Carolina Appleseed Legal Justice Center,
We have no cross for this witness. Thank you.
thank you. Nucor Steel, South Carolina,
We have no cross for this witness. Thank you.
thank you. Vote Solar,
We have no cross for Mr. Lawyer. Thank you.
thank you. North Carolina Sustainable Energy Association,
Madam Vice Chair, we have no cross.
thank you. Solar Energy Industries Association,
Madam Vice Chair, we have no cross.
thank you. Upstate Forever CCL SACE,
We have no questions for this witness. Thank you.
thank you. Alder Energy Systems,
Nothing from Alder. Thank you.
thank you. Commissioners, well, Mr. Lawyer, you may step down. Looks like you
Thank
got
Madam
off.
Vice Chair.
Thank you.
You're welcome.
Ms. Pittman,
Yes, at this time, ORS asks Dr. John Roof to take the stand. Just one moment, we're swapping witnesses.
understand. Thank you.
Madam Vice Chair, we're all set to present this witness.
Thank you. Dr. Ruth, please state your name for the record.
My name is John C. Roof.
Thank you. The court reporter will swear you in.
Dr. Roof, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Go ahead, Pittman. Thank you.
Thank you. Dr. Roof, please state your name and occupation.
My name is John Roof. I am the principal and owner of the Roof Group.
Are you the same John Roof who pre-filed 12 pages of direct testimony with this commission on October 8th, 2020 in this docket?
Yes.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
No.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes.
Thank you. Madam Vice Chair, ORS asks that the pre-filed direct testimony of Dr. Ruth be read into the record as if given orally from the stand.
Dr. Ruth's pre-file testimony will be entered into the record as if given orally from the stand.
Thank you. Dr. Ruth, did you file as an attachment to your direct testimony an exhibit marked as JCR-1, which consists of 7 pages?
Yes.
Do you have any changes, edits, or corrections to your exhibit?
No.
Madam Vice Chair, ORS that exhibit JCR-1 be marked for identification and entered into the record as the next hearing exhibit.
Dr. Ruth's pre-file direct exhibit JCR-1 will be marked for identification as hearing exhibit 14 and admitted into the evidence of this case.
Thank you. At this time, I'd like to walk Dr. Ruth through a brief Q&A to summarize his testimony.
Please proceed.
Dr. Ruth, can you please give a brief description of your educational background and professional experience?
I hold a PhD in history from the University of Illinois at Urbana-Champaign, as well as a master's degree from the same institution and a bachelor's degree both in history from Seattle University. Over the last 40-plus years, I have been engaged in issues around utilities and energy issues, including intervening as a pro se intervener in rate cases and rulemaking proceedings before the Commission from 1979 to 2002. I've engaged in policy work at the South Carolina General Assembly with a focus principally on low-income folks, but including significant work on energy and utility issues. I have testified numerous times as an expert in state and federal courts, as an expert in household economics, statistics, demography, social and economic matters, Southern history, Southern politics, elections, and voting rights.
Have you previously testified before this commission?
Yes, most recently I testified on behalf of ORS in the Duke Energy Progress and Duke Energy Carolinas general base rate cases about the impacts of the requested increases on customers.
Dr. Ruth, will you please tell us why you were retained by the Office of Regulatory Staff in this proceeding?
I was retained by ORS to address the impact of cost shift or cross subsidization of net metering customers by customers who do not have, do not want, and cannot afford to install solar generation.
Is rooftop solar accessible to all South Carolinians?
No. Due to the cost, rooftop solar is unattainable to many in South Carolina, where energy costs already holds. Solar energy has the potential to place an even greater burden on low-income households, households that do not and cannot access rooftop solar.
What demographic or demographics are most likely to invest in rooftop solar?
There's no state-specific data on the demographics in South Carolina, but national studies show that higher-income consumers are overrepresented among rooftop solar adopters, and lower-income consumers are underrepresented.
Why are lower-income consumers underrepresented among rooftop solar adopters?
There are a number of factors that influence the low distribution of solar adopters among low and moderate income families. Rooftop solar is unavailable in rental housing, the most common form of housing for lower income residents. Rooftop solar can cost between $12,500 to $25,000 in South Carolina, amounts far out of the reach of those of meager means. Tax credits that offset the cost of rooftop solar are rarely available to lower income consumers as they do not meet the requisite tax liability.
How do energy costs in general affect low-income South Carolinians?
Home energy bills are a crippling financial burden for low-income South Carolina consumers. Households with income below 50% of the federal poverty level pay 37% of their annual income on their home energy bills, and that is taking into consideration measures taken to reduce those energy bills, like keeping their homes at uncomfortable or unsafe temperatures, living in the dark, and foregoing basic expenses in order to cover their energy bills.
What is the impact on non-solar utility customers when the costs are shifted from net metering customers to the non-solar customers?
When costs are shifted from those that are able to access rooftop solar to those that cannot, the price of electricity goes up for those non-solar customers. Many of those customers would adopt solar if it were accessible and affordable. This subsidization by the lower income customers only adds to the high energy burdens and economic insecurities they face.
And what are you recommending of the Commission in this docket?
I recommend that this Commission take steps to ensure that low and moderate income customers who do not have access to solar and who cannot afford solar do not pay more for the energy in order to subsidize or incentivize rooftop solar. Additionally, I believe the Commission should challenge and encourage the solar industry to present creative ways to make solar adoption more attractive and attainable for low-income utility customers while maintaining a fair allocation of the costs and benefits to minimize any cost shift.
Dr. Roop, is this the appropriate document for your testimony?
Yes. This is the appropriate docket, as this is the docket to set the methodology policy for establishing net metering rates. Among the costs and benefits to be looked at are the costs to non-participating customers, especially low-income customers who will be especially harmed by any cost shift. If the Commission is asked to consider societal benefits justifying higher net metering rates, it should also look at societal harms flowing from those higher rates.
Dr. Roop, you heard Witness Beach testify that utilities can and should take proactive steps to address affordability of essential utility service for their low-income customers. What is your response to that statement?
While the utilities can and should take proactive steps, it is not on the utilities alone to do that. Solar companies also can and should take proactive steps to address affordability.
Does that conclude your testimony?
Yes, it does.
Thank you, Dr. Roop. Madam Vice Chair, Dr. Roop is available for questioning.
Thank you, Ms. Pittman. Dominion Energy, South Carolina, any cross?
No cross.
Duke Energy Carolinas, Duke Energy Progress, any cross?
Madam Chair, this is Ashley Cooper. We have no cross.
South Carolina Appleseed Legal Justice Center, cross?
Madam Vice Chair, this is Adam Prothero on behalf of South Carolina Appleseed. I do have a few questions.
Please proceed.
Thank you. Good morning, Dr. Roof. How are you?
I'm fine, thank you.
Good. I wanted to talk briefly about, let's start with Witness Beach's rebuttal to your testimony. He and some others have suggested that now is not the time to discuss energy affordability and cost shifting. Can you explain in a little more detail why the issues you raised in your testimony are relevant to these proceedings?
Well, clearly the impact on non-participating customers is part of the cost-benefit analysis that the Commission has to undertake in this proceeding, as much as an economic impact study, which failed to look at costs. Looking at the impact on non-participating customers is as much of that balancing act as the commission has to undertake as any of those other kinds of costs, particularly where those costs are not well defined, or benefits are not well defined.
Okay, thank you. And a good part of your testimony highlights how detrimental to low-income consumers any kind of a cost shift would be. Is that right?
Yes. As you well know, at Appleseed Legal Justice Center, low-income folks live on a razor edge of financial survivability. And so it does not take much to bring the house of cards down, crashing down, when you face additional costs.
And would you say that even relatively small cost shifts could bring that house of cards crashing down, as you put it?
Yes. I'm not sure what your question is.
No, I'm sorry. I was asking if you would agree that's the case.
Yes.
Okay, thank you. Witness Beach also, in his testimony, says that utilities, the Public Service Commission, the solar industry, and the state of South Carolina can develop programs to help low-income consumers. I wonder if you're aware of any programs that have either been developed or have been expanded, either as part of these proceedings or as part of the Solar Choice Tariff proceeding.
In South Carolina, the only ones that I'm aware of are the community solar programs that Dominion and the Duke companies have. And as I think you heard, I believe it was Witness Furtick describing the actual number of folks who are covered by the Dominion community solar program. It's not a lot. I mean, given that there are 129,000 low-income, below poverty families in South Carolina, what we see are drops in the bucket.
All right, thank you. Witness Beach also testified, I think, saying essentially that health benefits from reduced emissions, his assumption that increased solar energy production would reduce emissions, and can be of particular importance to low-income communities who already bear greater burdens from environmental degradation, I think is how he put it. Is he correct when he says that low-income communities bear greater burdens from things like pollution and climate change?
Absolutely.
And if this fact were used to justify a cost shift from net energy metering consumers to non-energy metering consumers, would you agree with me that we'd be asking low-income consumers to pay money that they may not have to fix a problem they shouldn't be facing in the first place?
Precisely.
Okay, thank you. I want to focus for a minute, too, on a little more detail about the cost, the idea of cost shifting and who that affects. I think you said that while South Carolina level data doesn't exist on the demographics of NEM customers versus non-NEM customers, national data shows that those who participate in rooftop solar tend to be higher income than those who don't. Is that correct?
Yes.
Okay. Is there any reason to believe that this isn't true in South Carolina as well?
Not at all.
Okay. Is it also true in South Carolina that African Americans and other minorities are overrepresented among low-income households?
Yes.
Okay. Would it be true to say then that if non-participating customers are made to bear any cost shift, that it would essentially be taking money from households that tend to be lower income, they're more likely to be minority, and giving it to households that tend to be both wealthier and whiter than they are?
Yes.
Okay. And Dr. Roof, as you read Act 62, is there anything in that act to keep the Commission from eliminating any cost shift from NEM customers to non-NEM customers?
Well, the Act calls on the Commission to eliminate the cost shift as much as practical.
Okay. Would a zero cost shift potentially be included in that universe?
Certainly would be.
Okay. Thank you, Dr. Roof. Madam Vice Chair, I have no further questions.
Thank you, Mr. Prothero. Nucor Steel, South Carolina, any cross?
No cross. Thank you.
Vote Solar.
Thanks, Madam Vice Chair. Thad Cully for Vote Solar. I do have a few questions for Dr. Roof.
Go ahead.
And I'm going to switch to my headset. Good morning, Dr. Roof. How are you today?
I'm fine, thank you, Mr. Cully.
Okay, good to see you again. And so in your testimony, I think you touched on something that really important, and that is the impact of the COVID-19 crisis on energy affordability. Would you agree that that has been a pretty unparalleled situation and challenge for ratepayers and low-income ratepayers in particular in South Carolina?
Yes, very much so.
And have you followed, as reporting then, the amount of debt that's been accruing in arrearages and other measures?
I am aware that there are substantial arrearages that are accruing, and but I haven't seen particular numbers.
But stepping out even of the COVID-19 context, you would agree with me that there is an affordability crisis in South Carolina due to high rates of poverty. Would you agree with that?
Yes.
And would you also agree that if there were no solar customers on the grid currently, we would still have that same level of crisis?
Yes. I mean, we've had it. I've been doing this long before solar was, other than a gleam in environmentalist eyes, and we had that problem 40-odd years ago.
Thank you, Dr. Roof. And you mentioned in your introduction here that you had participated and given testimony in the most recent Duke Energy Carolinas in progress rate cases. And was that on the issue of a high fixed customer charge proposal?
Yes, that was the focus of my presentation.
And would you agree, was your position that a high fixed charge was inappropriate as it pertains to low-income customers because it represented a charge they could not avoid?
Yes.
And would you agree? Oh, I'm sorry. Please finish.
Well, it's unavoidable. It's also unavoidable for higher income customers too.
All right. Were you aware of any testimony in that case regarding demographics as it related to relative usages of electricity?
Well, I testified, and there was survey data presented in each of the Duke cases regarding the composition of low-use customers. Historically, we would hear from the utilities that poor folks were all high-use customers, so you should give them that high fixed charge and low volumetric charges. But in fact, the data that I presented from the residential energy consumption study that's referenced in my report, and from the surveys that Duke presented in each of these cases, indicated that on average, lower income customers were low use customers.
Thank you. And would you agree that once a customer installs solar, they may not move from what we call or classify high use to low use, but would you agree that once a solar customer installs, they're going to be lower usage than they were before?
Well, one would think that if you mean lower usage, do you mean not lower use of electricity in their homes, but lower use of of power from the utility provider, yes.
Precisely what I meant. Thanks for clarifying my muddled thoughts there. So in that instance, would you agree that the solar industry, solar advocates, and low-income advocates had a somewhat of a common cause against a higher fixed charge because there was the same thread pulling, being able to avoid that charge was important to all groups? Would you agree with that?
Yes.
And would you rule out that there are more common threads that may be between the solar industry, solar advocates, and low-income customers and their interests of their energy burden if we were to look for them? Would you agree that there may be more threads we can find in common?
Well, I think there is no doubt that if we could expand the accessibility and affordability of solar to low-income customers, that those customers would be better off. The problem is, how do we accomplish that, and how do we not penalize low-income customers in the meantime?
Right, thank you. And would you agree, and I'm almost at the end here, would you agree that in the proceeding we are in right now, methodology and cost effectiveness, relates to low-income impacts?
I haven't heard any specific proposals on methodologies that address low-income impacts. That's why it's going to be important for the commission in weighing what they consider among the various not the cost of service study kinds of things, but stuff like the economic impact, the CO2 emissions was mentioned earlier today, how they weigh different considerations in establishing those final NEM rates, or the solar choice rates. That's where it's going to be important.
Okay, thank you. And would you agree that the solar choice rates that have now been proposed in at least one proceeding and will be proposed by Dominion, that will be handled in a separate docket?
Yes.
And would you agree? Oh, I'm sorry.
But this is sort of setting the groundwork for what will be decided in those dockets.
Sure, thank you. And when it comes to coming up with creative solutions on the part of the solar industry and solar advocates, would you agree that it's really important to have an inclusive process?
Well, without an inclusive process, certainly gets you to better places. If we look around and one of the places I go to see what's happening good for low-income solar is Vote Solar's website. There are lots of people who have to participate because part of the bottom line in all of those programs around the country is somebody has to get up off some money in order to make these programs work. Whether that's, and it happens in various places in various mixtures, utilities, solar industry folks, municipal and state government folks, private foundations. So there are a number of things that can be done, particularly if you pull together a broad range of stakeholders who recognize going in that caring about low-income folks isn't enough if you don't do something about it. And in the meantime, though, it's also important that we not continue to burden the low-income folks with subsidizing those who are able to access solar now.
Okay, thank you. And when it comes to ideas that work for low-income solar access expanding, would you agree it's important to really understand conditions on the ground in South Carolina to build a program that will best serve South Carolina?
Clearly, you know, the literature on this, and I cite the Solar Justice report in my report. One of the things they emphasize is that while there are lots of successful programs around the country, they're still in the experimental stage, and they differ from community to community about what will be successful.
Well, Dr. Ruth, thank you very much for your testimony. I have no more questions for you. Have a great day.
Thank you, Mr. Culley. North Carolina Sustainable Energy Association, any questions?
We have no questions, Madam Vice Chair.
Solar Energy Industries Association, any cross?
No cross, Madam Vice Chair.
Upstate Forever CCL SACE, any cross?
No cross. Thank you, Madam Chair.
Thank you. Alder Energy Systems, any cross?
No, ma'am. No cross from Alder Energy. Thank you.
Thank you. Commissioners. Commissioner Williams.
Thank you, Chairman Belser. Dr. Roof, it's nice to see another history major and focused person. It's interesting where we end up, and good to meet you.
Good to meet you.
I have two questions. One has to do with the cross-subsidization, and wondered in your analysis if you looked at particularly at commercial and industrial customers and the potential cross-subsidization there, and whether it happens to the extent that we have received testimony related to residential solar.
No, I haven't looked at that. No one asked me to.
Okay. I understand. And then simply, your suggestions talk about private solar industry offering creative ways to help with solar adoption and make it more attractive for low-income utility customers. Do you have suggestions? Perhaps there's some in the footnotes that I'd love to look at.
I would go to two places. One, I would look at the Vote Solar website, and I think you need to go Vote Solar low income, because they have a separately titled website on that has a number of examples around the country, and the Solar Justice report that I do cite in the footnotes.
Does anything in particular stand out?
Well, you know, it is my sense that there are some that are more promising than others, and community solar is probably the most promising for low-income customers to be able to access solar. But, you know, we have a problem in that our code pretty much limits community solar to the utilities, and their programs are, you know, good as they are for, like, you know, what was it, 165 folks who access it, it ain't enough.
Thank you, Dr. Roof. Appreciate it.
Any other commissioners? Hearing none. Ms. Pittman, any redirect?
Thank you, Madam Vice Chair. No redirect.
Thank
We'd ask
you.
that this witness be excused.
Dr. Roof, you may stand down. Thank you for your testimony and your appearance today. It's good to see you.
Thank you.
Council, we're bumping up against 11:30, and as I earlier discussed, we need to break for an early lunch. So I reckon we will proceed with ORS's witness at 1 o'clock. And thank you for your understanding and your consideration in this early lunch. We'll see you at 1 o'clock. Thank you.
Thank you.